Okay, I think we are getting started here. Thanks everyone for joining Legal Aid's Protection Order Case Law webinar. My name is Pat Caraher. I just wanted to mention a few things before we get started. I wanted to mention that the majority of the funding for this project comes from the Omaha Community Foundation's ARPA grant. So we do thank the Omaha Community Foundation. Some work on this webinar was done by attorney Shannon Konkol and her law clerk, Renee Horsley, and their work is made possible by a grant from Equal Justice Works. So we thank Equal Justice Works for their contribution as well. I also want to thank Jenna Heineck, who does a fantastic job as Legal Aid's marketing and communications manager. Jenna's leaving Legal Aid, but she leaves us better than how she found us. So we will always be grateful for Jenna. My name again, Pat Caraher. I've been doing family law cases at Legal Aid since 1987. I became managing attorney of the Lincoln Office of Legal Aid in 2009. I became the statewide director of the family law unit here in 2019. Here with me today, as I mentioned, is staff attorney Shannon Konkol. Shannon is an Equal Justice Works legal fellow at Legal Aid of Nebraska. Her work involves representing victims of crime in underserved communities in civil matters, including protection orders, custody cases, and divorces. Shannon graduated from the University of Nebraska in December of 2022 with both her Juris Doctorate and her Master's of Political Science. This webinar has been approved for 1 hour of continuing legal education credit from the Nebraska State Bar Association. We will provide the activity number near the end of this program, but to make sure that you get credit, please put your name and bar number in the chat, or I guess if your full first and last name are the same as your Zoom name, we'll be able to get your name there too. But my suggestion is put your name and bar number in the chat, and that will ensure that you will get the CLE credit. So let's move on to the next slide, Shannon. I think you're operating this stuff. So this is our land acknowledgement statement. If any of you have seen webinars from Legal Aid of Nebraska in the past, you know that we always take a moment just to have everyone realize and remember and recognize that the original inhabitants of the land that we're standing on were members of some of these proud Native American tribes. Moving on to our mission, Legal Aid of Nebraska's mission is to promote justice, dignity, hope, and self-sufficiency through quality civil legal aid for those who have nowhere else to turn. Next slide will show some numbers. Legal Aid, Nebraska's largest nonprofit law firm. We have over 100 employees. 93, that means we can reach all 93 counties in the state of Nebraska. Legal Aid has 7 office locations: Omaha, Lincoln, Bancroft, Norfolk, Grand Island, North Platte, and Scotts Bluff. As I mentioned, some of the work on this webinar was done by Shannon and her law clerk, Renee, and their work is made possible by a grant from Equal Justice Works. And this indicates that the opinions, findings, conclusions expressed in this webinar do not necessarily represent the official position of Equal Justice Works. We're about ready to start talking about protection orders. In the past, we've done some webinars basically about the statutes on protection orders. We're not going to spend much time on that today because we want to get to case law, basically Nebraska Court of Appeals and Nebraska Supreme Court. But let's take just a second here and take a look at the 3 types of protection orders, just so everyone is familiar with what we're talking about. We call the domestic abuse protection orders DAPOs, the sexual assault protection orders SAPOs, and the harassment protection orders HIPPOs. Just looking at some of the differences there. For example, they all are in effect for 1 year, but only the DAPOs and SAPOs are renewable. Only the DAPO has temporary custody, which makes sense because it's only in a domestic situation that people would have children and would need a custody order. Hearings are required for both a DAPO and a SAPO. That means a judge can't just reject a request for a domestic assault protection order or a sexual assault protection order, but a judge can just reject out of hand without a hearing a harassment protection order. A new addition to the domestic assault protection orders are pets. You can get protection orders over pets in a DAPO. And under the statute, when someone violates a DAPO or a SAPO, they are to be arrested. And that language is not there for the harassment protection order. Okay, now we can start actually diving into the cases. And I believe this first category of cases, I'm going to turn things over to Shannon and let you talk about these, Shannon.
Thanks, Pat. So this first section are cases where the court found there was not enough evidence to grant the protection order. So first we have Watson v. Mackey. This one came out just this past year in Lancaster County. The facts of the case: the girlfriend, Watson, filed a harassment protection order against her ex-boyfriend, Mackey. In that, she made general allegations that he was fixated on her, that he messaged her every day, begged her to take him back, etc. The district court granted the protection order. The boyfriend appealed. In the appeal, he pointed out that they continued to have sexual relationships after some of the allegations, and after the police told him to stop contacting her, he did. So the holding from the Court of Appeals, they reversed the order, and they found that there was not a course of conduct directed at Watson which seriously terrified, threatened, or intimidated her, and that served no legitimate purpose. Next case is Luberski versus Luberski. This came out in August in 2023 out of Platte County. In this one, the dad filed the protection order on behalf of himself and his 3 kids against his ex-wife. In that protection order, he alleged that the ex-wife was intoxicated. She drove with kids in the car, crashed, and got a ticket for criminal mischief. She was also charged. He also alleged that she was charged with felony child abuse from another incident, but didn't reference what that incident was, and that a person claiming to be a CPS investigator called the home and made the daughter uncomfortable, but he did not allege that it was the ex-wife who made the call. He also alleged generally a history of substance abuse by his ex-wife. So in this, the district court granted the DAPO. However, the Court of Appeals reversed and remanded because they found that there was not sufficient evidence to meet the legal definition of abuse, and there was not found to be a credible threat of bodily harm. Next, we have Prentice v. Steed. This was actually in Douglas County in 2020. In this one, a reverend named Prentice and his wife filed for a protection order against Miss Steed, who had sent some threatening texts to the Prentices about the Prentices church, saying things like, "I will have your broke-ass church destroyed." At the hearing, the Prentices failed to offer their petition as evidence. Miss Steed's attorney had evidence from law enforcement that the text did not actually come from her. And the judge said he believed that, however, the judge said that he believed Miss Steed had something to do with the text and granted the protection order. The Court of Appeals ended up reversing, saying that there was not sufficient evidence to support the petition. The court noted that the statute had been changed to say the petition should have been offered into evidence immediately, but at the time of the hearing, the petitioner still had an affirmative duty to offer the petition. Without that evidence, there was little to support the allegations, so the Court of Appeals felt like it had to reverse. Next, another important case was Erickson versus Swenson. This came out last August out of Douglas County. In this one, the ex-husband Erickson filed for a protection order for himself and his 2 kids against his ex-wife Swenson. The ex-husband said that the ex-wife had not responded to texts, which made the kids worried. But when she came over to assure the kids she was all right, she launched into a rant about the new girlfriend of the ex-husband. Another incident the ex-husband alleged is that when he came to get the kids from her, the ex-wife punched him in the head. At the hearing, it was revealed that the second incident happened several years ago, leaving just that one recent incident. The recent incident was also captured on video, which the husband offered into evidence. The court said the video shows that the ex-wife did make very many vulgar statements, but it also showed that there were many times where she was ready to leave and the ex-husband would make a comment to exacerbate the situation. The court said that in this incident, the one incident, the ex-husband was engaging with the ex-wife, did not appear to be afraid, and this is not a course of conduct which would seriously terrify someone. So the protection order was not granted or was remanded. Next, we have, for the last one of this section, we have Tundra versus Ballina. This came out of Madison County in 2023. A mother filed for a protection order on behalf of her son against the son's former employer. The son was 15 years old. The mother alleged that the employer had a criminal case pending, and the employer promised her son certain things. As basically, the employer was 25 years old, and the mother did not like him befriending a 15-year-old. There was also allegations that the son was allowed to consume alcohol at the place of employment under the employer. The county judge granted the protection order. However, the Court of Appeals reversed because the evidence did not show anything that would seriously, again, terrify, threaten, or intimidate a reasonable person. Next, we have cases in which the court found sufficient evidence to grant it. And Pat, this will be Pat.
Okay, thanks, Shannon. Yes, so these are cases in which the court did uphold or grant the protection order. The first one is Hawkins versus Delgado. This was a Nebraska Supreme Court case from 2021. A Douglas County judge granted an harassment protection order. Both parties were first lieutenants in the Air Force. It was a boyfriend-girlfriend relationship, a long-distance relationship. And when the girlfriend would occasionally threaten to end the relationship, the boyfriend would respond by threatening to commit suicide. She finally did end it, and when she did, he sent her a video message with a noose around his neck. And he also sent messages that were kind of vague, but kind of scary. Messages like, "Time has come, karma." Another message, "It won't stop till it all burns." Another message, "There is a storm coming. Afterwards, there shall be calm. You will be free from yourself and your past." So vague things, but kind of scary. And at a hearing, the girlfriend said she lives in fear each day because of these messages. And the Supreme Court of Nebraska found that these statements did meet the definition of harassment because they did seriously terrify or intimidate. So that order was affirmed. Next case is Ditter versus Cush, 2023 case from the Court of Appeals out of Platte County. This case involved a property dispute between two adjoining landowners. So it had to be a harassment order. They weren't in a domestic situation. These were neighbors, basically. Ditter went over to talk to Cush about their land dispute. And when he did that, Cush tripped him, slammed his head to the ground, kicked him in the stomach, and Ditter was in the hospital for 5 days after that. Ditter filed for harassment protection order as neighbors. His petition said the dispute had been going on between these two neighbors for 2 years. At the hearing, Cush and his wife both said Ditter was the aggressor. On appeal, Cush argued that this did not meet a course of conduct definition for harassment protection order because it was only one incident. However, the Court of Appeals pointed out that while this may have been the first physical incident, the dispute had been going on for 2 years, so it was a course of conduct, and the Court of Appeals did affirm the harassment protection order. Our next one, Robert M. on behalf of Bella O. versus Danielle O. The Nebraska Supreme Court decided this case out of Sarpy County in 2019. The father of Bella O filed for a domestic assault protection order on behalf of Bella against Bella's mom. The incident actually occurred in the state of Minnesota. Robert, the dad, lived in Nebraska. Danielle, the mom, lived in Minnesota. And Danielle got visitation with Bella up in Minnesota. Well, during one visit, the mom physically attacked two family members, her mother and her brother. So not Bella, but Bella was present. The Supreme Court of Nebraska said that the mom's conduct was not directed at the child, but the court granted the protection order, and the Supreme Court affirmed because the conduct was a credible threat. Credible threat means any verbal or written threat with the ability to carry out the threat and the ability to cause reasonable fear for safety. And here, even though the attack was on these other family members, it was enough to cause reasonable fear for Bella. There was no discussion in this case about the fact that the incident happened in Minnesota. I have had cases where people argue, well, Nebraska doesn't have jurisdiction if the incident happened in Minnesota. And while this case doesn't discuss that, I think it would be a good case to mention if someone argued that, because clearly the Supreme Court of Nebraska must have felt if Bella was in fear here in Nebraska, Nebraska had jurisdiction to grant a protection order. It doesn't matter that the incident happened in Minnesota. Nebraska still had the authority to enter a protection order. Next cases, I'll turn over to Shannon.
So the next section is going to be on visitation, between parents between a child for visitation of the children. So the first case is Rachel C. on behalf of Clayton R. This is a Court of Appeals case from 2023 out of Buffalo County. The mother filed the petition and the affidavit on behalf of herself and the two children, seeking a protection order against the father of her youngest child. At the show cause hearing, the district court dismissed the protection order as to the mother and the oldest child, but continued the order for the youngest. The father appealed. The Court of Appeals upheld the protection order, but said that no contact between the child and the father for a year would hurt the relationship. This is something we all know, this concern. Judges do not want to slap a one-year order on a parent that will cause the parent to have no contact with their kid. So here, the court ordered visitation with the protection order, within the protection order. They remanded the trial judge to set up telephone, video, or supervised visitation. And this is the first appellate decision that we're aware of where the appellate court ordered visitation during a protection order. A few months after that last case, we got Cody H. versus Catherine H., which also involved protection or visitation within a protection order. And the visitation was ordered by a trial judge, and the Court of Appeals didn't really discuss that issue. This case was out of Dakota County, came out in January of this year. The husband filed for a DAPO for himself and the child. Of the parties, it was against the wife/mother of the child. He alleged some incidences where the wife hit him after he made a joke, and she slapped the child in response to the child slapping her. The trial court ordered an interim order, giving the husband temporary custody and giving mom every weekend from Friday night to Monday morning for visitation. The Court of Appeals reversed both the protection order for the husband and for the child. And one of the reasons that they reversed for the child was because the court's interim visitation order. The Court of Appeals said that because the mother got pretty liberal parenting time, it's clear that she must not actually have presented a credible threat of bodily injury to that child. This next one will be cases discussing future harm.
And the future harm issue is a big issue in protection order cases because a lot of times the respondent will say, even if it happened, you shouldn't slap a protection order on me because there's just no risk of any future harm. And the main case on the issue of future harm is this Maria A, OBO, Oscar G, and Leslie G. This was a Supreme Court case out of Saline County from 2018. Again, it's really the leading risk of harm case in Nebraska. Maria and Oscar were the unmarried parents of two minor children, Leslie and Emily, and it's undisputed that Dad hit Leslie. He hit her several times in the leg. She had broke her, I think, stepbrother's electronic tablet. Dad got mad. He chased her down while she was lying on a bed. He hit her leg 5 times. So that clearly happened. And the mom, Maria, filed for a domestic abuse protection order on behalf of her daughter. And at the hearing, it came out that Leslie was afraid at the time it happened when Dad was hitting her on the leg 5 times. But the evidence came out that by the time of the hearing, Leslie missed her dad and missed seeing her stepbrothers and was no longer afraid of her dad. So the district judge down there in Saline County rescinded the ex parte protection order and went up on appeal. And the Supreme Court started their opinion, first of all, by making it clear that the burden is always on the petitioner to establish a prima facie case. That's usually done with a petition and affidavit. And then the burden shifts to the respondent to show cause why the order should not remain in effect for 1 year. Anyway, they set out that procedure, which made that clear. But more importantly, the Supreme Court said in this case separating the father and the daughter for 1 year would cause more harm than the incident itself caused. The court found that because there was no risk of future harm, the judge's decision should be affirmed. Now, Justice Miller-Lerman wrote a very lengthy dissent on this case. She disagreed with that opinion, but today you hear this argued a lot in protection order hearings. The respondent will say she's, even though it happened, she's not really afraid because look, she's been calling me, or look, she spent the weekend at my house, or look how she acts. She's no longer afraid. So even if it happened, there's an argument that the protection order should not remain in effect if there is no risk of future harm. And that's really the main case on that. So I think that's the only case we'll discuss on future harm. There are cases on remoteness, and I'll let Shannon talk about those.
This first case is the Ditmars versus Ditmars. This case it's a Court of Appeals case from 2010. It was one of the first big ones about remoteness in Nebraska. This involved a decision of a county court judge in Lancaster County. So in this one, the wife filed for a DAPO on behalf of herself and her son. In this, the alleged actions were pretty serious. However, the incidents that she alleged occurred in April and September of 2009 in Kansas. She didn't file her petitions until she moved to Nebraska, and that was in November 2009. The husband had not contacted her after she left Nebraska. The county judge did grant the request of the DAPOs. However, the Supreme Court reversed it, saying the actions were too remote in time to show that the wife was in fear of bodily injury at the time of the hearing. Basically looked again at that idea that he had not contacted her after she left Kansas. The next case is Sarah K. versus Jonathan K. And this is where Ditmars gets cut back some. In this one, this was also a county judge from Lancaster in 2015. The wife filed on behalf of herself and the minor daughter. There were some pretty serious allegations of abuse, such as like a chokehold, and the allegations that the 1-year-old actually saw these incidences. At a hearing, the husband argued that the last incident was on November 6, 2014, and the hearing for the protection order was February 20th, 2015, so about a 12-week difference. The father also had left her alone since the last incident, and his attorney argued for the Ditmars case and said that the incident was too remote. That trial judge disagreed, and the Court of Appeals disagreed. 12 weeks ago, they decided it was not too remote. Court pointed out to Ditmars that since that case, the statute had been amended, and imminent bodily injury was actually changed to just fear of bodily injury. Imminent was removed from the statute, and 12 weeks was no longer too remote. The last case is Amanda F. versus Daniel K. This is a Supreme Court decision from Nebraska out of last year, and this comes out of Scottsbluff County. The parties in this case dated in 2018 and 2019, and at some point when the parties were together, Daniel sexually assaulted Amanda. He was charged criminally. He had a trial in 2022, and he was acquitted in that trial. The day that he was acquitted, Amanda filed for her SAPO. At the hearing, the evidence was found that Daniel had left Amanda alone since 2019, primarily because there had been no contact order in the criminal case. Also, at the hearing, his attorney argued there was no risk of harm since the parties were no longer seeing each other, 3 years had passed, and there had been no new incidences. It's also worth noting that future harm doesn't really apply to SAPOs. The trial judge's interpretation of the SAPO statute was that there was no need of risk of harm to be evidenced. However, the Supreme Court of Nebraska disagreed to the extent that they said the risk of harm is a factor in SAPOs. And even though 3 years had passed, the remoteness of the incident did not mean the risk of harm had gone away. So the Supreme Court of Nebraska did affirm the SAPO in this case. The next part will be, oh, sorry.
That's sure. Thanks, Shannon. looking at cases involving renewal of protection orders. We are seeing more and more renewals since that statute was passed a few years ago. There's really one leading case on renewals, and that is Garrison versus Otto. Garrison was a 2022 case out of Lancaster County. It went to the Supreme Court of Nebraska, and they said this was a case of first impression because it was the first Supreme Court case to really deal with renewal of protection orders. Again, the domestic abuse and sexual assault protection orders can be renewed. Harassment orders cannot be renewed. In this case, the parties had been married years ago. Mr. or Ms. Garrison had remarried, but Mr. Otto continued to cause problems for Ms. Garrison. The most recent incident had involved swerving his car at her and her new husband, and she was granted a domestic abuse protection order back in 2020, based in part upon this swerving car incident. Then in 2021, she filed to renew, and at the renewal hearing, both sides testified again and presented evidence about the swerving car incident. There had been no new incidents. The trial judge found there was no requirement of a new incident for renewal. And while remoteness is an issue, that doesn't mean a new, more recent incident is necessary. And while the court found that a renewal is not a chance to just relitigate the same issues over again, which I'm sure a lot of judges were happy to hear. The Supreme Court of Nebraska agreed with the trial court, mentioning that renewal is only for 1 year. You know, I think there was a bill in front of the legislature that would have made renewal available longer, maybe a couple of years. And maybe if that would ever happen, they would put a tougher standard on renewal. But here they're saying, look, this is only renewing for 1 year. Clear that the statute says a new incident is not necessary. So if nothing happened during the year that the protection order was in place, that just means the protection order is working. So Garrison versus Otto really stands for the idea that you do not need a new incident to get a renewal of your protection order. The only other case we know about that involves a renewal is Allen versus Allen. This is the first time we've seen a second renewal come up in an appellate case. This was a Court of Appeals case out of 2023 from Sarpy County. Back in 2020, the wife was granted a 1-year domestic abuse protection order against her husband because of his threats and because of his actions against her. In 2021, she filed to renew. She said that she had gone to his criminal sentencing, and at his criminal sentencing, he stared her down so much that the judge doing the sentencing had to warn him to stop staring at his ex-wife. And the renewal was granted. And then in March of 2022, she filed for a second renewal. And, you know, I remember when the renewal statute first came out, some attorneys thought you could only renew once because it didn't really say in the statute, but clearly that's not right. As happened in this case, this was a second renewal. There's really no reason why someone couldn't keep renewing on and on other than remoteness when the incident gets to become just so remote in the past, or maybe at some point the risk of future harm decreases. But other than those issues, you can keep renewing as the petitioner did in this case. And here Ms. Allen said that during this most recent year, she had reported Mr. Allen for a probation violation, and she knew that he knew that she was the one who reported him, so she was still afraid of him. He had not had any contact with her. He hadn't done anything as far as a new incident, and the judge in the case made comments on the bench saying, reading the statute, it looks like renewal should just be automatic. But then he went on to say there was an argument that maybe it wasn't automatic, and he gave the parties a chance to argue. After he renewed the protection order, Mr. Allen appealed, and the basis of his appeal was he said the judge shouldn't have just said it was automatic, but the judge didn't really say it was automatic. And clearly, renewals should not be automatic, but that tells you, if the judge is thinking that the standard is pretty low, and that's what we've seen. We've seen a lot of renewals get granted. Courts do need to weigh the risk of future harm. And the court in Allen did say they were unsure if the trial judge had assessed future harm, but even if he did not, they can do a de novo review, and they found there was future harm, and they decided that the renewal should be affirmed. Next category, Shannon.
So the next one we have to talk about is subject matter jurisdiction. The first case for that one is Jacobo versus Sultanco. So this is a Court of Appeals case. It originally comes out of Box Butte County in 2021. In this one, the mother filed for a protection order on the behalf of her son against the boy's father. She filed in Box Butte County. She lived in Alliance. The father lived in Hitchcock County. The parties also at the time had an open custody case in Kearney County. The incident that caused her to file was when her son was with dad in Hitchcock County. At the trial court, the judge in Alliance issued an order without a hearing, saying that because the events did not happen in Box Butte County, I do not have a jurisdiction, and he dismissed. Mom's attorney filed a motion to amend or alter, but that was denied, and she appealed. At that appeal, the Court of Appeals said that district courts clearly have jurisdiction over protection orders. They have the ability to transfer venue to a more appropriate county if it's necessary, but they do not and not allowed to just dismiss by saying they do not have jurisdiction. The next case is DW versus AG. This is a 2019 case, comes out of Douglas County, and it's a Supreme Court case. DW and AG were college students. They went out for a night of drinking. DW woke up later that night to find AG sexually assaulting her. She filed for a SAPO. At that hearing, AG's testimony was quite different from DW's allegations. He said that DW was coherent that night, that she had told him that if they had sex, he had to promise not to tell her boyfriend. And an acquaintance testified that he talked to the parties and they were coherent. Surveillance photos showed the three people talking. The trial judge said that he could not find a lack of consent regarding the sexual assault allegation, so he did not issue the SAPO, but he did issue a HIPPO. On appeal, AG argued that the court did not have subject matter jurisdiction to issue the HIPPO. Court of Appeals said that it had subject matter jurisdiction. That was not the problem. The problem was due process. That AG did not know a HIPPO was a possibility, so he didn't know he should prevent evidence on that issue until it was too late. That problem of notice is pretty much being cured because the statutes now state that everyone is now on notice for any kind of order may be entered. So if you file for a DAPO and the court finds that DAPO cannot be allowed, they can still issue like a HIPPO or a SAPO. Next one, we got personal jurisdiction.
And I would think there would be more personal jurisdiction cases or subject matter jurisdiction cases, but we really don't see that very often in these protection order appeals. This case did touch on personal jurisdiction. This is Paul K. versus Christian G. And I believe this was a Court of Appeals case and a Supreme Court of Nebraska case. It was appealed up to the Supreme Court after a decision from the Court of Appeals. This decision came out just in January of this year, so it's a recent case. It was an appeal from a district judge in Lancaster County. Paul and Christian were the unmarried parents of one child. Paul filed for a domestic abuse protection order for herself against Christian. He lived in Iowa, and he was sent a copy of the ex parte order, and he got the form to fill out if he wanted a hearing. I'm sure if you've done protection orders, you've seen those. They get served with a form that says, you need to fill this out if you want a hearing. He filled that form out and he sent it in. The court set a hearing. Then Christian did not get notice of that hearing and he didn't appear. And the court entered a 1-year protection order. Eventually, Christian found out what happened. He hired an attorney. That attorney filed a motion to vacate the order, arguing that the court lacked personal jurisdiction over him. However, both the Court of Appeals and the Supreme Court of Nebraska said he waived personal jurisdiction issues by filling out the form and sending it in. The Supreme Court said by filling out that form and sending it to the court, he had entered a general appearance. Christian's attorney argued, his client had to send in the form. That's what was sent to him. And it does seem unfair. A unrepresented, a pro se litigant gets sent a form from the court and they fill it out and they send it back in, not realizing that they are in fact waiving some defenses, waiving some arguments, and entering a general appearance. But the Supreme Court of Nebraska said nothing in the statutes says you have to fill out the form. And what he should have done was filed a motion objecting to personal jurisdiction only rather than a general appearance. So I think that's a little bit of a harsh outcome, but that's the decision of the Nebraska Supreme Court. If you fill out that form and submit it, that is a general appearance, and you are waiving issues such as personal jurisdiction. Shannon.
So we have two cases about that need for a hearing and the hearing procedure. So the first one is the one that I had already mentioned, the Jacobo case. We just talked about this one for subject matter jurisdiction. However, this one also applies to this one because the other part of this case was the Court of Appeal said that it was wrong to just dismiss this case without a hearing. You cannot dismiss it. The judge cannot dismiss a case without a hearing for a DAPO or a SAPO. The next one comes out of Colfax County in 2023. In this one, Coach sent a mailing out to a number of people that was basically pro-life literature. One of the people he sent it to was Susan S., and she wrote back, "Thank you for the misinformation. I'm making a donation to Planned Parenthood in your name." This upset Coach, so he filed for a HIPPO against Susan. The district court in Colfax County dismissed it without a hearing. In that order, the judge said the facts alleged do not allege a course of conduct that seriously terrifies, threatens, or harasses as defined in the statute. The court further finds the contentions frivolous and assesses costs to Coach. In his pro se appeal, Coach had complained that he should have at least gotten a hearing. However, the Court of Appeals said HIPPOs, unlike DAPOs and SAPOs, can be dismissed without a hearing if the court finds the petition does not state a valid claim. This is the one big significant difference between HIPPOs and DAPOs and SAPOs. Another difference is, again, that the HIPPOs cannot be renewed, but we'll move on to the last one, which are just miscellaneous cases.
And I would say a couple of things about these cases. As Shannon says, they are just kind of miscellaneous cases. The first one I'll talk about is Elston versus Elston. So this came out in 1999, a long time ago, and I was involved in this case. And I do want to point out that Legal Aid has been involved in probably about a third of the cases that we've been talking about today. I can't remember them all, but I know Amanda F. and Jacobo, maybe Ditmars, and a few more that we've yet to talk about. So I do think Legal Aid has a lot of experience in dealing with these protection order issues. And I remember being at the hearing in this Elston versus Elston case. I remember it quite well because the judge kind of shocked me a little bit. But anyway, this again was 1999, went to the Supreme Court of Nebraska out of Lancaster County. Mr. and Mrs. Elston were a married couple. Mrs. Elston filed for a domestic abuse protection order, and the district judge granted it, but limited the order to say that Mr. Elston just had to stay away from Mrs. Elston's residence. You don't see judges doing that these days, but that's what the judge did back there in the 90s, said, I'll grant the order, but the only place he has to stay away from is her house. Well, we had a hearing on that, and the judge asked some questions of Mr. Elston, and we got done. Our attorney said, can I ask some questions? And the judge said, no. The judge then questioned Mrs. Elston, and when the judge got done, our attorney, I was sitting there, I was her supervisor, and she said, Your Honor, may I ask some clarifying questions? And the judge said, no. So the judge left the limited protection order in place, and Legal Aid appealed. Mr. Elston actually cross-appealed on some of his own issues, but in the end, the Supreme Court of Nebraska reversed the judge for saying no. They said a judge does have the right to limit the scope and extent of attorney examination, but a judge cannot just totally deny an attorney the chance to question a witness. Next one of these miscellaneous cases is Alicia M. versus Duarte. This case came out in January of this year out of Douglas County. It was a Court of Appeals case. Alicia filed for a domestic abuse protection order against Duarte. That would be a former boyfriend of hers. Duarte was also charged criminally with assault against Alicia. Well, he filled out the form requesting a hearing on the protection order, but as it happened, the day of his sentencing for his criminal assault was the same day as the hearing on the protection order. So he got sentenced for the domestic assault, and as he was being taken away by the sheriffs, the judge realized, oh, the next hearing is the protection order hearing. So he had the sheriffs bring him back. And he asked the guy, well, are you still contesting this? You know, you just got sentenced for domestic assault. And the guy said, yes, I do want to contest it. And the judge just said, sorry, we aren't doing this. Granted the protection order, told the sheriffs to take him away. And I can understand the judge's feeling on that, but that was not acceptable. Duarte appealed, the Court of Appeals reversed. They said, even when the entry of a protection order appears inevitable, the parties still must be given their due process rights. So that was reversed and scheduled for another hearing. I'm pretty sure I know what the outcome of that next hearing was, but at least Mr. Duarte got his day in court. The next one, Torres versus Morales. I believe this was a legal aid case out of the Supreme Court of Nebraska in 2014 out of Lancaster County. Torres filed for a domestic abuse protection order against her boyfriend, Morales. The incidents involved him being intoxicated, grabbing her shirt, yelling, calling names, elbowing her. And at the hearing, Mr. Morales said, you know, we argue a lot. This order might actually be a good thing for both of us. And the judge said, are you contesting the order? And he said, no, I'm not contesting the protection order. But the judge went ahead and denied the protection order anyway and assessed costs to Ms. Torres. She appealed, and even though the Supreme Court of Nebraska affirmed the denial of the protection order, they did reverse on the issue of costs. This was an important legal aid case, as I remember, because we had a judge who was assessing costs every time he didn't grant the order. Basically, he would order the woman to pay cost if he did not find in her favor. That's not what the statute says. Statute says you only assess costs if it's found that the action was brought in bad faith. And so it was important to do this appeal and to win this appeal. We did that in this case, and the court reversed that part of the order, and that judge did stop ordering cost every time he ruled against a petitioner in a protection order case. I think we do have a little bit of time left, so I'm going to talk about federal law. So far we've been talking about Nebraska Court of Appeals and Nebraska Supreme Court, but I am going to mention one federal case. There is a federal statute that makes it illegal to possess a firearm if you have a protection order in place against you. Now, every state has different wording for their protection orders, but Nebraska's order is fairly similar to other states. Basically, if you have a domestic abuse protection order, you can't possess a gun or else you're violating a federal crime. Well, we're expecting a decision on this any day now, but there is a pending case in front of the Nebraska Supreme Court on this issue. That is United States versus Rahimi. I'll try to run through these facts a little bit. It's out of the Fifth Circuit Court of Appeals. It's a 2023 case, now on appeal to the Supreme Court of the United States. Back in 2020, Rahimi was involved in 5 shootings in and around Arlington, Texas. And on December 1st of 2020, after selling narcotics to an individual, he fired multiple shots into that individual's residence. The following day, he was involved in a car accident. He exited the vehicle, shot at the other driver, fled the scene. He returned to the scene in a different vehicle and shot at the other driver's car. 2 days later, he shot at a constable's vehicle. On January 7th of 2021, he fired multiple shots in the air after his friend's credit card was declined at a Whataburger restaurant. The officers in the Arlington Police Department identified Rahimi as a suspect in the shootings, got a search warrant, executed the warrant, found a rifle, and also found that in addition to possessing firearms, he was the subject of a civil protective order entered in 2020 by a Texas state district judge regarding the assault of his ex-girlfriend. The protective order prohibited Rahimi from committing family violence going within 200 yards of her employment or possessing any firearms. Federal grand jury indicted him for possessing a firearm while under a domestic violence restraining order, in addition to several other crimes. But the district judge in Texas found that the federal statute was unconstitutional, that it violated Rahimi's Second Amendment rights. That got appealed to the Fifth Circuit, which covers Texas. They agreed and said the statute about guys can't have a gun when they've got a protection order, they said that violated his Second Amendment rights. That all comes from a case, the Brune case, which had come out a couple of years ago. It went to the United States Supreme Court. There were oral arguments in November. There was a lot of stuff in the news back then, judges asking questions. And now the court is issuing opinions, and they expect an opinion probably within the next couple of weeks. We're going to find out if the United States Supreme Court says this guy's Second Amendment rights keep him from allow him to possess a gun. It seems to me the facts are really bad, and they should want to say this guy should not be going around with a firearm after all the shootings that he's done. But we'll see. We'll find out from the United States Supreme Court. Could be today or tomorrow, but definitely they say within the next few weeks we'll get an answer. And that's important also because I think Nebraska has a statute that makes it unlawful for someone to possess a firearm when they're under a protection order. So that would probably invalidate both the federal statute and the Nebraska statute. So that's one federal case to touch on. We are now at about 10 minutes left. We do have time for questions and answers. I don't know if anyone posted anything in the chat. Jenna, did you see any questions get posted?
I don't see any in the chat, but if anyone wants to add some into the chat, they can, or you can just come off mute and ask your question.
I was wondering how the court justifies that a threat is not ongoing just because the victim claims that they feel safe. You know, they say that there's no future threat. And you know what I mean?
Absolutely. You know, and I forget the case that had the sexual assault was one of our cases. And they did say in that case, even though 3 years had passed, there was still a threat. And we'd made the argument that when it's a sexual assault protection order, you don't even look at future harm. If it's sexual assault, it's just inherently a bad thing, and they should grant that. But you're right. The Maria A case talked about future harm. You know, that Maria A case, again, the facts are it's a little girl who wants to see her dad and who wants to see her stepbrothers. And they say she's not afraid of her dad anymore. She wants to see him. So let's look, is there future harm? Now, that's a whole different fact pattern than what we usually see in protection order cases where they raise us, as I said earlier. Now it's the boyfriend who comes in and says, well, look, she called me. Oh, she came over. She spent the night with me. There's no risk of future harm. That's a lot different than a little girl who's going to be prevented from seeing her father for the next year because of a protection order. So I don't like seeing that future harm being a defense being used in some of these cases involving, you know, adult girlfriends and boyfriends, when really that came from a case involving a child. So I agree with that concern, but that's what the state of the law is right now.
Pat, it looks like, oh, sorry, there was one question in the chat from Julie, who said, do you know of any cases that focus on solely social media posts on a Facebook group, but the individual is not contacting the petitioner directly?
Shannon, have you read these cases? Was there one case where they were at least threatening? I don't need to put you on the spot, Shannon. Anyway, if you have anything to add, say so, but I remember one case, but I don't remember it very well. You have any thoughts on that, Shannon? Or if Mark's on the line?
I mean, like the Hawkins case did talk about it was all threatening messages, text. I don't know about social media, but that one was pretty much a lot of the evidence in that one, and they found that sufficient evidence was enough, was all text.
And what weren't they at least threatening to expose the other side on social media, something like that? But anyway, to answer the question, there was that one case that Shannon just talked about, but that's the only case I'm aware of. I know that's been a issue with the legislature, social media, and revenge porn. And some people say we already have laws that protect that. We don't need more laws. I'm not an expert on those issues, but I will say that's the only case that we know of in a protection order context that it comes close to addressing that kind of an issue. We've got a few minutes left. Nobody has comments, questions? 8 minutes. We have to do 8 more minutes in order to give you your full CLE.
Hi, this is Hazel. Just kind of similar to the first question, when they're looking at the future risk of harm, like in the little girl situation, I can see why you might not want to do a whole year, but maybe some kind of restrictions, because, you know, a young girl might want to see their dad, but that doesn't mean that that doesn't represent a risk if there has been abusive behaviors. So I guess in your opinion, how do the judges weigh that, or what are they looking at in terms of establishing future risks? It can't just be that the victim is saying, okay, I'm fine now, because the victim might be manipulated or in fear of saying otherwise.
Well, I know Shannon had those cases about visitation. Remind me of what that case hold again, Shannon?
The future harm one, or which one?
Well, wasn't there the judge didn't want to slap a full 1 year protection order on a parent, so he said, okay, protection order is granted, but you get visitation, or I don't know if that was every other weekend.
Oh, the Cody H. Yeah. So for that one though, that was more of there must not have been that there was no credible threat of bodily injury because of the fact that the court gave such liberal parenting time.
That's right. If the court gave liberal parenting time, then there must not be, you know, it's just complicated. And we always tell people when they come in and they want protection orders on their children that these judges do not like to slap a 1 year protection order on a parent and deprive them of visitation for a full year. Kind of try to discourage that. You know, the judges absolutely think that's something that should be dealt with in a custody order, visitation order, or parenting time order, not a protection order. Sometimes it's justified, and we've certainly seen judges do it. We've argued for it, but it's just it's a difficult situation.
It looks like we have another question in the chat. When a petitioner files to vacate or dismiss the protection order, is a hearing required? Some judges seem to grant those, other judges seem to deny them.
Yeah, I don't think the statutes say what's needed. I've absolutely filed a motion to dismiss, and judges are happy to get rid of protection order and sign it easily. On the other hand, I remember Judge Paul Merritt, who's no longer on the bench, deciding he would schedule his own hearing, and he brought parties in and he asked the woman, went through her complaint or her petition, said, well, here you allege, you know, he had alcohol problems. Has he been through treatment? Well, no. You know, is he going to A? No. And he goes, well, then I don't think that issue's been addressed. And he refused to grant her motion to dismiss. He went through a lot more issues than that. But so I think a judge is free to schedule a hearing and question someone. But I think it's totally up to the judge on that. So we are almost at our full hour. I see we do have the activity number up there, 266-826. That number again, 266-826. Get your activity number. Looks like everybody put in their bar number. I appreciate everybody joining the webinar today. Thanks for all the positive comments. Everybody have a great day. Take care. Thank you.